Thursday, everyone. I'm Katie Merrill. I'm the Dean of Admissions, and I'm joined here by my colleagues, Shirley Crawford and Ellen Doobie. I'm also joined here by Dean McCormick, who's going to teach a class tonight, and it's 5 tips for better professional writing. We're really excited. First and foremost, I'd love to hear from you. I know I have some regulars on here, but I'd love to hear if you're an admitted student, if you're a prospective student. I'd love to hear what state you're from. I'd also, this is a side note, Director Crawford mentioned to me about it's National Lost Sock Day. So maybe your opinion on how many socks you've been missing over the years. I was just thinking it's always the good ones that go missing. So that's a fun fact. Professor. Oh, Boston. Okay. Dean McCormick, that's some of your stomping grounds there. Yep, I know. Hello. I love our regulars. Dallas, Texas, New Jersey. Oh, yes. I wanted to know if you're online hybrid or residential student. Thank you for reminding me, all of you out there, what program you're interested in. Texas, South Carolina, hybrid. Oh, Savannah, Georgia. We have a number of alums in Savannah. I was thinking about that for the alumni panel. Maybe we could get Robert Baker. Oh, future hybrid. Hi, Raphael. Virginia, Michigan, New Jersey. Howdy. I like howdy. That's a good way to say hello. All right. With that, Dean McCormick, I'm going to pass it on to you if you want to talk a little bit about the hand raising, things like that. That would be terrific.
Thank you, Katie, and welcome, everyone. I'm so pleased to be with you tonight. I want to just first introduce myself to those I haven't met before. I'm Beth McCormick. I'm the Dean of the Law School and a professor of law. I've been at Vermont Law School, at Vermont Law and Graduate School for about 13 years in a variety of different roles before I became the dean about 3 years ago. I'm also one of the people who played a lead role in creating our online hybrid JD program, and it's a program I'm immensely proud of. And it's one that I also teach in. So since our program started, I've been teaching civil procedure in the online hybrid JD program. And so if you decide to enroll in our program, about half of you will have me and about half of you will have my colleague, Professor Stephanie Clark. Tonight, I'm not going to talk about civil procedure. I wanted to teach a class tonight that was more something that you could implement and use right away in your jobs now or in your application materials. And so tonight's class is going to focus on 5 tips for better professional writing. I should add that before I joined the faculty at Vermont Law School, I was a practicing litigator in Boston at a law firm named Mintz-Levin. And what I learned as a litigator was that writing was the most important class that I took in law school, and that you could really distinguish yourself as an outstanding attorney with really great legal writing skills. And so I've taught lots of legal writing skills during my career at Vermont Law School as well. So that's what I thought I'd focus on tonight. So during this class, it'll be interactive, only if you want. There'll be no Socratic method in this class tonight. So I want to tell you a little bit about how to raise your hand. If you open your meeting chat and you click on the emojis, you should see an option for a hand raise. So you can go ahead and give that a try right now if you want. And then what I do during my normal online hybrid JD classes is we don't really use the chat during class unless I ask you to use the chat during class. And so sometimes I'll ask a question and I'll ask you to give me your answer by a thumbs up. So I'm going to go ahead and write in the chat right now. Actually, I can't seem to write in the chat right now. Hold on one second. Thumbs up. So you can just thumbs up, and that's how you might say yes if I ask a question, or sometimes I might put multiple choice answers in the chat and ask you to thumbs up the one that you think is the right one. All right, with that, let's get started. So my plan for you today is I'm going to show you a little bit about what I consider the #1 goal of good legal writing. And then I'm going to give you 5 specific tips that I hope help you achieve that role. And I'm actually going to stand. I have a standing desk here because I like to stand when I'm teaching because it really makes me feel like I'm in the classroom. And I should probably introduce you to my dog, Doug, who is in the background as well. if you join our program, you'll certainly meet Doug at one of our 3 residencies throughout the program. He always comes with me, and we have dog walking office hours in the morning. So you'll get a chance to meet him later as well. The first thing I want to tell you is that good legal writing is really just good writing. So the tips that I'm going to show you today really apply to any type of professional writing and not necessarily legal writing. So good legal writing is the same thing as good writing. And there are some special technicalities that you're going to learn in legal writing 1, 2, and appellate advocacy when you're at Vermont Law School or wherever you choose to go to law school. But generally speaking, good writing is good legal writing. The other thing I like to tell students right from the start is that writing is a skill, and that's good news for us because that means you can get better, right? So any skill, the more that you practice, the better that you get. So a lot of times students say, I'm a terrible writer, I'm not going to succeed in law school. And I tell them, you are, because writing is a skill and you're going to work on it, you're going to practice it, you're going to get better at it. One of the best ways that I have found to get good at legal writing or writing is to read examples of good legal writing or good writing. And so I really encourage you to start making that a practice of yours. One great free source to read good legal writing is the SCOTUS blog. So SCOTUS.com, it's a free blog, and it really assembles all of the briefs written in all pending U.S. Supreme Court cases. So you'll find all the historical cases, the cases that are currently before the court, cases that are pending, cases that are coming up in the next year or two. You'll find every brief. And I have found that the best legal writers in the country are those that write briefs for the U.S. Supreme Court. So you can kind of start reading some of those, find a case you're interested in that maybe you know the facts of a little bit, and you can start reading those and start kind of taking note of the things that you see in that style, and you can steal that and you can make it your own style. That's what I did when I got to my law firm as a new associate, just having graduated from law school. I wanted to become the best writer at the law firm. So I asked around, who's the best writer at the law firm? And I heard it was this attorney named Andy. And so I started reading everything that Andy wrote, everything I could get my hands on, every motion, every brief that he wrote. And I tried to take note of the things that he did that I thought were good. And I stole Andy's style for a little while, but then ultimately adopted my own style, which now I share with students. Okay. So I want to first start with what I think is the number one goal of good professional writing. And to get that answer from you, I'm going to ask you this. What do you think is one thing that all legal writing readers have in common? One thing that all legal writing readers have in common. So you can either go ahead and raise your hand or you can write the answer in the chat if you'd like. Okay, I'm getting some great answers in the chat. Got some hellos to Doug. He appreciates that. They want to understand the argument. They have a desire to learn. They want to identify the argument. They're looking for an answer, knowledge of the material, clarity. They're short for time. That's my favorite answer so far, although all of these contribute to that. And I think that's the right answer, right? All legal writing readers are busy, right? So who are our legal writing readers? Judges, other attorneys, clients, professors, if you're in school. And all of these are busy people that have a lot to do. And so you want to write and communicate with a legal writing reader or a professional reader in a way that supports that number one goal. Because the real risk, if you don't, especially if you're in court and your legal writing reader is your judge, and you haven't written in a way that's clear and easy for them to understand from the start, is that instead they're not going to spend the time trying to figure out what you're trying to communicate, and maybe they're going to listen to your adversary instead. In fact, there was a Michigan Law Review study several years ago where judges throughout the state of Michigan were surveyed, and they were given examples of writing that used some of the principles we're going to talk about today and samples of writing that didn't. And the judges actually reported that the ones that used the principles we're going to talk about today had a stronger legal argument, even though that was the same legal argument. And I really think that's remarkable, that just the quality of your writing in the judge's view, an experienced legal writing reader, made the argument stronger. So think about that, right? If you don't have the strongest argument, but you can communicate it in an effective way using some of the principles we're going to talk about today, that might even, in the judge's view, improve the quality of your writing. It's remarkable that writing can have that effect. And that's why we want to hone that and make that a really strong skill for any type of lawyer that you want to be. All right. So that's exactly right. The number one goal of good legal writing is to make things easy for your reader. So I want you to take a look at this passage and tell me what you think. Give you another 15 seconds to read it. All right, so go ahead and thumbs up if you agree with this statement. And then I'm going to give you in the chat, this is not good legal writing. And tell me, thumbs up, whichever one you think, that this is good legal writing or not good legal writing. Okay, I'm seeing some not good legal writing. Good, good, good. Okay, does anyone want to tell me some of the things? I agree this is not good legal writing, right? And I agree it's not good legal writing because I don't think it supports the number one goal of good legal writing. And to prove that, I'm going to see if there's any brave volunteers out there to tell me what this says. If I don't get any brave volunteers, I'll make Katie do it.
So I think the first half of the argument is very well put. I come from a family law firm, and so, I can kind of understand that first part of it. I think where it kind of falls off is the bottom half, the doctrine of the anticipatory breach, which operated to free the petitioner to seek and obtain a source for substitute performance. That's another defense that they could have used, kind of gone into more detail.
Okay. What does manifestly mean? Do you know?
Like, I do, but I'm not coming up with the words, so I'm gonna let somebody else.
I agree. So manifestly is a word, like I feel like I sort of know what it means, but it's not a word I use ever, right? Haven't used the word manifestly in conversation or in my own writing ever. And so right there, the very first word, I'm sort of like, that's not a familiar word to me. So it is not a word that I use often. So that to me does not support that number one goal of good legal writing. Yes, I can make out what the first part of this means, right? But there's some other problems as well. It's very long, right? Taylor, did you have to read it more than once to figure out what it meant?
I had to read each word like probably 3 times as long as I normally take to digest a sentence like that.
Yeah, so that's not supporting the number one goal of good legal writing, right? If my reader has to read my writing multiple times to understand what I meant, then I failed, right? Because they're not going to do that. And most often, your professor will, of course, but the judge is most often not going to do that. And then maybe they're going to rely on your opponent's argument instead, if that's more easily to understand. So this whole sentence fails that number one goal of good legal writing, right? So I know it's bad, but I got to figure out what are the things that are wrong with it so I can figure out how to fix it. Manifestly, that's exhibit A, right? Because that's not a word. You want to use words that are generally understood by people and not words that someone has to go look up in a dictionary or Google to find out what it means. What are some other, and we already talked about how it's a long sentence, very long sentence. A lot of people noticed that it was too wordy. What are some of the other problems that you see in this? Anyone? I've got an answer. Big words. The conclusion doesn't match the premise. Boring writing is certainly boring, right? And legal writing does not need to be boring. And you're going to see that in another couple of slides for an example. What do we think about these words like of, to, with, of, before? A lot of ofs in here. I'll tell you about of in a second. Anyone know what they are called? Go back to 8th grade grammar. What are those little words called? Prepositions, right? And good. So these are prepositions, and this isn't one of the rules that I selected for you today, but I'm going to talk about it. One of the things I tell my students is you want to avoid the 3 Ps in good legal writing. Avoid the 3 Ps, which are prepositions, pronouns, and passive voice. We're not going to talk about these too much today, but we see an example here of a ton of prepositions: to, with, of, all of those words before. Those are all prepositions. You don't need to eliminate them. You'll never be able to write with eliminating prepositions, but you want to minimize them where you can. Often when I'm reading student writing, the first thing I do is I circle all the prepositions if I'm having trouble understanding what a sentence is. And I encourage students to go ahead and try to rewrite, minimizing those little preposition words. And I always call of the ugliest of the prepositions because it is sort of makes your writing clunky, but the good news is it's the easiest to eliminate as well. You can often eliminate of by just using the possessive instead. Okay, so our number one goal of good legal writing is to make things easy for our reader. And the first rule I'm going to give you 5 rules today about how you might do that. The first rule I'm going to give you is to replace flabby ION or TION words. Okay, does anyone know what those are called? Flabby ION words. I'll give you some examples. It's called a nominalization. It's the noun form of a verb. So it's when you take a verb and you make it a big clunky noun instead, right? And we love to do this. We do this instinctually. One of the legal writing scholars that I read a lot, you're going to see a quote from him in a couple of slides. He said that the only people that like nominalizations are lawyers and bureaucrats, right? So we don't want to be that kind of lawyer that likes nominalizations. They're words that end in ION or TION. They result in an abstract noun and a weak verb. And instead, you want to use the short, concrete verb instead. I'm going to give you some examples in a second. This one's a super easy one to spot because you just want to use the search find function on your computer and then search for any word that ends in ION or TION. And then when you find that word, look for the hidden verb that's in there and use that short, concrete verb instead, right? Super easy to fix this one. Examples. Instead of saying are in mitigation of, we're just going to say the lien replacement of mitigate. Instead of saying conduct an examination of, we're going to say examine. Instead of make accommodation for, accommodate. Make provision for, provide for, and so on and so forth. And you can see, if you just listen, if you ignored everything else I said, and just made this one adjustment, your writing's automatically going to become leaner, more clear, more easy to understand, and in better support of that number one goal that we have. Doing this has an added payoff, right? Because you see, when you're using the flabby ION word here on the left column, in almost every case, we've got an of and an in. We've got those prepositions. They're often surrounding it. So really, by doing this, you meet 2 of my rules. You get rid of the clunky noun, and you also get rid and minimize prepositions in the process. So this is a really helpful tip that you can immediately implement. Let's look at the payoff. So take a look at this little passage and see if you can identify the nominalizations in here. I think we would all agree, and I'll stop talking so you can read in 1 second. I think we can all agree that this isn't easy to understand. We've got to read it a couple of times to figure out what it means. I'm still not really sure. And then see if you can identify the nominalizations. Okay, we've got modification. We've got application to. Good. Revocation, good. Got application again, consideration, good. Suspension, there's a lot of them in here, right? And that's what's contributing to making this difficult to understand, right? So let's look at the pay. So I think I've underlined them here, right? And now let's look at the payoff. If all you did was get rid of those nominalizations, you now have something that makes sense. An interested party may apply to modify or revoke an anti-dumping agreement or to terminate a suspension agreement during an annual administrative review. The board normally will not consider revoking an order unless there have been no sales at less than fair market value or fair value for at least 3 consecutive years. Okay, so that one transformation has automatically made this passage better. And I want you to imagine making just that one adjustment, sentence to sentence, paragraph to paragraph, page to page in a 15-page document. You're automatically transforming your document from kind of clunky to lean, clear, easy to understand, supporting that number one goal of good legal writing. All right, tip number 2. Shorter is always better. Legal writing readers are busy, right? So if you can say something in fewer words, fewer pages, shorter sentences, please, please do that. This might be hard for some of you to accept, right? So maybe you're coming out of college, or maybe the last paper you wrote was in college, which is fine. And you had like a 20-page limit that you had to get to. And the paper had to be 20 to 25 pages, and you knew you had to get on that 20th page or you're going to lose points, right? So you're messing with the margins, you're messing with the font, you're trying to find more things to say to meet that page minimum. In my legal writing classes, there is never a page minimum. There is only a page maximum, and you should not be getting anywhere close to that page maximum if you're following my rules, because shorter is always better. Sometimes I get pushback on this from students because they'll say to me, well, it's a complicated concept. I really need to have longer sentences or more words to explain this complicated concept. I don't agree, right? Because to me, if you can't explain a complicated concept in shorter sentences and fewer words, you don't truly understand that complicated concept. And only when you truly understand it can you communicate it with fewer words, shorter sentences, fewer pages. So I reject that argument. I always hear that from my students every year, but I reject that argument. And you'll see the Supreme Court briefs, if you start to look at them, that so many of them use short sentences, short paragraphs, not too many pages, but are able to communicate possibly the most legally complex ideas facing our country today in these SCOTUS briefs. All right, so I mean that shorter is always better at the sentence level and at the page level, but here's some examples of some concise replacements that replace wordy phrases that lawyers love to use, right? But not us anymore. So instead of saying during the time that, you say while. Instead of saying for the reason that, you say because. Lawyers love to say notwithstanding the fact that, you can just say although, one word replacement for those 4 words. So on and so forth. Imagine these transformations paragraph to paragraph, page to page over a long document. I've got some additional slides that show you how. You don't have to say cease and desist, right? No one really says that. You can just say stop. You don't have to say whether or not. You can just say whether, right? So here are some examples of how you might use a concise replacement to a wordy phrase and really transform your writing. I also mean it at the sentence length. And this is one of my most important rules. Good legal writers, good professional writers, control their average sentence length. I'll say it again. Good legal writers control their average sentence length. And ideally, my favorite, different professors have different preferences, but I like to keep my average sentence length 12 to 18 words or fewer. Okay, 12 to 18 words or fewer. I don't mean you have to count every word in your sentence. Microsoft Word will do that for you. I'll show you how to do that in just a second. But you want to keep that average. And I'm not saying you can never have a sentence that's more than 18 words or more than 12 words, but you want that average. That's going to be the best writing when that average sentence length is 12 to 18 words. And in fact, really, writing and good writing is like music. There's a rhythm to it and there's a pace to it. So sometimes the best writing has a very long sentence followed by a very short sentence. And that's how you keep that average to 12 and 18. That's what you're going for, average. That said, if you are someone that feels like you struggle with writing, and don't be ashamed, many of my students do, right? If they think that they're not good writers, again, it's a skill. You practice, you get better. You read good legal writing, you get better. You have great teachers, you get better. All of those things. So nothing is fatal. And it doesn't mean that you're not going to be a successful law student if you think your writing skills aren't very strong. But if you do feel that way, just take this one tip and do nothing else. Just say, I'm going to make sure every sentence in my paper is 12 to 18 words. I'm not going to worry about having some long and some short. I'm just going to make sure every sentence is 12 to 18 words. That's going to result in a paper that's easy to understand. It might not be the most dynamic writing because you want that mix of short and long to make it really dynamic, but it's going to be a paper that is easy to understand. So that's a great place to start if you want to immediately start trying to improve your writing. I mentioned one of my favorite legal writing scholars is this writer named Brian Garner. He edits the Black's Law Dictionary. I've heard him speak, and I've read all of his books. And I love what he has to say about this, right? Because he says, the English language has vast potential for verbosity. Almost any writer can turn a 15-word sentence into a 20-word sentence that says the same thing. And many writers could make it a 30-word sentence. And a truly skilled verbiage slinger could lard it out to 40 words without changing the meaning. And in fact, almost all writers subconsciously lengthen their sentences this way, but reversing this process is a rare art. So he means that it's a rare art because people don't do it, but it is not hard to do, to break up a complex sentence into 2 sentences. We just did it with the nominalization sentence. I saw a hand up, so let me take a question.
Sorry, Dean McCormick, that was me. Hi, I'm Kate.
Hi, Kate.
Kind of curious because in my professional career, a lot of times they want it lengthier. So I definitely like the advice for the legal writing component. Has it ever happened where it gets too concise, where it's almost too choppy, where the idea is not clearly put across? Does that ever happen or no?
Not in my opinion, because you can always eliminate the choppiness with using a variety of transition techniques, right? So there's 3 different types of transitions that I usually use in my writing. Sometimes it's just a transition word like therefore, for, or clearly, or therefore, or furthermore, something like that, for example. Sometimes it's just these short conjunction words like you see here, and people think you can't do that that's illegal in grammar, but it's not. And the best legal writing readers use these short words as transition words to make 2 sentences together so it's not choppy. And then there's another technique you can use called echo links, where you finish a sentence with one idea and then you start the next sentence with the same idea, which really smooths out any writing that could be seen as choppy. In my view, I'm not sure what your job is, but in my view, the only people who intentionally write long are intentionally trying to confuse. Maybe that's not, I make room for the possibility there might be an example where that's not true. And I know science writing is its own sort of breed. So sometimes science writing is a little bit different. Like science writers love the passive voice, where, it's not allowed. You can't even speak in the passive voice in my class. I don't allow it. Can't say on your answering machine or your voicemail, your call will be returned. You have to say, I will return your call. So this is what Brian Gardner has to say, and it is something that I have really seen students implement successfully to completely transform their writing. So I encourage you to give it a shot. Now, with all of my rules, you can break them. Okay, you can break them. Certainly break them if your job requires it, but you can break them if you have considered it and decided that breaking them supports my #1 goal of making things easy for your reader, right? You never want to break my rules out of a lack of discipline or failure to recognize that you're breaking my rules. But if you have thought about it and consciously said, I'm going to break this rule here because I think it's going to support my #1 goal of good legal writing better, then you can do it. And I've got an example I'll show you in a minute of someone that's really truly broken one of my rules. Hold on, let's go to the next slide. All right, so let's just first take this and practice for a second. So this is, I think this, I forget how many words this sentence is. I'll count while you're reading, right? So I want you to transform this whole mess that you see right here into 6 words. Okay, 6 words that says the same thing. I'm going to count the words that are there. I think it's 50 something. And let me give you a little context. I know you're still reading and counting, but let me give you a little context. So this, I ran into this when I was preparing for a legal writing class on this lesson. And it was one of the biggest law firms in the world, not the law firm I worked, but one of the biggest law firms in the world, was in a very public billing dispute that had gotten a lot of negative press. And they were accused of overbilling their clients. And some emails had been found that were suggested that they were sort of making the bills more expensive. And their managing partners put out this long statement, and this was the first paragraph in the statement. It's important to emphasize that the client was not overbilled, so on and so forth, right? And I read this, top lawyers at this world's largest law firm, and I think you did overbill your clients because this feels defensive to me, right? This feels defensive to me. And I see a lot of people in the chat have given me some examples onto how to fix this. And I love Lucy's. We did not overbill the client. 6 words, right? Using the active voice, not using nominalizations. That says the same thing as this 50-word mess says here, right? Confident, strong, dynamic, clear, short, right? And to me, that's what I would believe. And then you can explain a little bit more about it if you want. But all of these 50 words, all they say is we did not overbill our client, right? So top lawyers at the biggest law firm in the world produce this. We can produce better. We did not overbill our client. Now, let me tell you how really good legal writing readers, we did not overbill our client, will break the rules sometimes. So this was a decision. This was from a dissenting opinion from Justice Scalia. May he rest in peace, who I didn't always agree with Justice Scalia's opinions, but I sure did admire his writing, because anyone who says legal writing is boring has never read a Justice Scalia opinion, because he was not a boring legal writing writer. And so this was a case called Edwards versus Aguilar. I have the site here at the bottom. It's a 1987 case, and it involved the First Amendment. And essentially, to synthesize a quarter's or a semester's worth of constitutional law in 30 seconds, you're not allowed to use you're not allowed to support or advance a religion as a government, right? It can have an incidental benefit, but you're not allowed to support or advance a religion. You violate the separation clause or the free exercise clause in the First Amendment. And so this is his dissent, okay, rejecting the majority's opinion that a legislator's opinion was to advance religion. So just go ahead and read this 100 and something word, not a mess, but this 100 and something word sentence. So tell me what you think of this passage. I may not have given you enough time to read it, but Amy says, wow, good. Lucy says long, but at least it's fun to read. And his point is distilled clearly in the last sentence. And I agree, right? This is a very long sentence, but do we think it's hard to understand? In the chat, tell me, is this sentence hard to understand? No, it is not hard to understand, right? So even though he's using 100 and whatever words in this first sentence before the second sentence here, it is not hard to understand. He's written in a way that it's clear. He's used a technique here, parallel construction, where every phrase has the same part of speech in the same tense. And so that really makes it easy for a reader to understand a long list. So that's a technique you can use if you do want to write a long sentence. He's also followed this really long sentence with something much shorter, right? Which is a great technique as well. And he has decided, right, to use this long sentence for an intentional effect to overwhelm the reader with all of the different possibilities, which is what supports his legal argument and his dissent, right? So he's consciously done that. He's not done that out of a lack of discipline or failure to recognize that he's writing a 100 and something word sentence. So again, break the rules if you think that it supports that number one rule of good legal writing, and never because of a failure to recognize it, the rule, or a failure or a lack of discipline in your writing. So yeah, Scalia has really colorful opinions. So I really encourage you to take a look if you're interested in seeing how a really great legal writer writes. All right. Oh, here it is. If you want to check your sentence length, you just highlight it, and Microsoft Word tells you at the bottom. So that sentence was 174 words. But you can also use enable in Microsoft Word readability statistics. And then once you do that, it'll tell you your average sentence length when this little box comes up. So you can see for this writing, I wrote this way back when I was assistant professor of law many years ago. I have 22 words per sentence. So that's above the average of where I want to be. So that would be a cue to me to go back and do some editing to get that average sentence length in the 12 to 18 point that I really want it to be. All right, I'm going to keep going. I've just got a couple more tips. So I want you to read this one And I want you to tell me if when you read this description, this is something you might see in a facts description or a facts section of a brief for legal writing. I want you to tell me if you can visualize what's happening as you read this passage. Okay, I'm getting a lot of yeses in the chat. We like this, right? We like this. This is good writing, right? We can visualize exactly what's happening here. This is good writing. What are some of the characteristics of this passage that we think makes it so good? Very descriptive. So what writing techniques has this author used? There's some detail, active voice, great, Kelly. I love the active voice. Everything here is in the active voice. Good description of location of the various parts, good sentence length, excellent, Judy, pardon me. Great sentence length. I don't know what the average sentence length is here, but it's probably lower than 12 or maybe around 12. So all of those things are good. Anything else that we can tell? Specific word choice, easy to read, and it flows. Okay, all that's good. I want you to focus on the verbs. Focus on the verbs and see if you can see any pattern. Okay, we're talking about the tenses, simple active verbs, good. I think I have a slide that really highlights the verbs, and I'm going to say them out loud. Stopped, saw, had, yelled, show, raised, pulled, did, saw, had, raised, was, yelled, had. What do we have? What's in common with all of those words I just said? Each represents a pivotal moment. Yes. Short. Yes. Kelly, more like that. How many syllables? One, right? Each one of these verbs is one syllable. We call these monosyllabic verbs, right? Some of you probably never thought about before, and neither had I until I read it in a book that was written by Noah Messing. He's a legal writing professor who was at Yale at the time that he wrote the book. And he really talked about the power of monosyllabic verbs. He said, try enlivening your prose with strong monosyllabic verbs. Noah Messing, The Art of Advocacy. It's a great book if you ever want to read it. He's got an appendix in the back that has 5,000 monosyllabic verbs for you to choose from. And when I started looking into this, I could really see its power, right? That using a one syllable verb, especially in a descriptive facts section of a brief, can really just transform that writing, making it so dynamic, easy to follow in that way that we thought was good, where we could absolutely picture what happened. So they're easy to comprehend. They please your reader's eyes and ears. He says, use the commonplace ones as much as you want, like want, take, find, act, lead. And then he says, use friskier monosyllabic verbs occasionally, like bilk, blind, cramp, dwarf, drown, doom. And that's another thing that will make your writing more interesting. One thing I did when I was trying to become a great legal writer was every time I read something and I saw a word used in a different way than I would think of it, when I saw sort of any interesting word in legal writing, is I kept a notebook at my desk where I would write it down. And then when I was editing my own writing, I would look at my list to see if there were any words that I could put in. And so, like I said, he has this list of 5,000 verbs. One of the verbs he has on that list is meow, which I feel like you could make 2 syllables easily. And one year, this is before I was a dean, one year I challenged my students to use meow in their oral argument for appellate advocacy, not thinking anyone would try, but one person did, and he did it. He seamlessly wove in the word meow into his oral argument before Vermont judges and lawyers in a way that I was not embarrassed by. So I don't play those games anymore now that I'm a dean, but it can be fun to be in a legal writing class. this is how I know, or this is how I knew that Noah Messing was right. So this passage is the facts section in a very famous torts case that you will all read in your first year of law school when you take torts, called Palsgraf. And it's written, this opinion is written by Judge Cardoza. And it's sort of a famous opinion. Every one of you is going to read it in torts class, all right? But I want you to read the fact description that Justice Cardoza wrote describing this situation. So take a moment to read it. This fact section is often pointed to by legal writers as a really brilliant way to describe the facts because, again, of the way that you can picture it and you can see what happened. The case is about whether you should have foreseen that there was something dangerous like fireworks underneath this newspaper. But this is often pointed to and used in legal writing classes as an example of a great descriptive fact section. And when you really look into it, right, you can see that it's filled with those monosyllabic verbs. Right? You can see it's absolutely filled with it. Go, stopped, bound, ran, catch, reach, seem, jumped, fall, reach. All of those are monosyllabic verbs. And really, short sentences, active voice, plus monosyllabic verbs, that's how you create something like this that people will talk about 100 years later as being an example of good writing. So try enlivening your prose by using one-syllable monosyllabic verbs. All right, I'm on to my last tip. And so for this last tip, and you may have seen this before, if you've seen this before, don't help me give this experiment to the other students. But what I want you to do to introduce this last tip is to read this passage and count the number of F's that you see. Count the number of F's that you see in this passage. So I'll give you a minute to do that. You can go ahead and write your answers in the chat. As you can see in the chat, we're all over the place. We have 4, 7, 8, 10, 11, right? And it's funny that we're getting all of these different answers to something that feels like should be an easy task, right? For budding lawyers like yourselves. But I understand why many of you have gotten this wrong, right? I believe 11 is the correct answer here. And here they are in green. Is that 11? 1, 2, 3, 4. 5, 6, 7, 8, 9. Yeah, I think so, right? And the reason, well, someone tell me, what's the reason, if you didn't get 11, what's the reason that you didn't get 11? Which ones did you miss? Okay, D. Frazier says he didn't count the ofs, right? Jennifer, everyone's saying they didn't count the ofs. And that is exactly right. So most people who get this wrong skip over those ofs, right? And they're focusing on the other Fs, powerful, effective, fears, fear, right? And they're failure. They're skipping over the ofs. And why do you think you're skipping the ofs when I asked you to find the Fs? I think the reason is because the F in of sounds like a V, right? So when I said F, you're thinking of an F sound and you're skipping of because that F sounds like a V, right? And that's probably why students don't always get all of the Fs in this relatively simple exercise. And what it does is this example really shows to me why proofreading is so difficult. So tip number 5 is proofread with a passion, right? Because there's nothing that thwarts that number 1 goal of good legal writing, making things easy for our reader, than them being distracted by your proofreading mistakes, distracted by your typos, right? If they do that, not only may you lose credibility with your reader, right? Which you don't want to lose credibility with that judge, but also, right, maybe they're just going to be too distracted to even bother trying to figure out what you're trying to say. So proofread with a passion is tip number 5. It's also the hardest on my list of how to master proofreading, right? The gold standard for proofreading is time between when you finish writing and when you're actually turning something in, right? We probably have all had the experience where we've turned something in and we read it the next day and we're like, oh my gosh, how did I miss that, right? Because time is the gold standard. What happens when you're proofreading is that your brain is telling you what you think or wanted to write and not what's actually on the page. And that's what happened with our of example as well, right? I said of, or I said F's, you thought the F sound and you weren't looking at what was right in front of you on the page. And that's why proofreading is so hard. Time's the gold standard, but I also know that's unrealistic. It's unrealistic for me. It's unrealistic for law students, especially unrealistic for online hybrid JD students who are often working all day long before they're going to class at night. So here are some other tips that can help you improve your proofreading. The goal is to sort of break that connection that your short-term memory has so that you can actually see what you wrote on the page. So enlarging the font size on the computer to 20 or 22 point can be effective to do that. The number one tip I have used over the years is voice to speech. So I'll use the narrator or voice to speech read aloud function on Microsoft Word, and someone reads to me what I wrote as I follow along on my computer screen, and that I can hear the mistakes that I can't see on the screen. So that's been the number one goal for me in correcting any mistakes. Katie and I have a big board meeting next week, and we're going to be doing that for our PowerPoint presentation. So make sure we don't have any typos on that screen when we present to the board. Using that Control F function on your computer, find and replace, right? We already talked about using that for TION and ION nominalization words, but you can also use it for things that you often misspell. You can use it for apostrophes, so you can kind of zero in on your apostrophe to make sure that you're using it in the right way. You can use it for quotation marks to make sure every time you have an open quotation, you've got a closed quotation. You can use it for what I call the 3 great grammar gaffes. These are the sort of grammar mistakes you make when you're hurried, but you know the rule. There, it's, your, right? Those ones. If you often make that mistake when you're in a hurry, you can use the Control F function to land on every time you use that word so you can scrutinize it and make sure that you've used it correctly. Of course, you want to be careful with spell check, and you want to watch out for these particularly troublesome words. I call these the spell check 7, right? Because these are words that come up all the time in the law, but are often you get the wrong word in a spell check situation. So instead of talking about a statute, someone will write statute. Instead of talking about united, they will all see untied, right? From if form are also often confused. I'll always see briefs talking about reasonably suspicion when I know they mean reasonable suspicion. Of course, probably cause when they mean probable cause. And of course, the always embarrassing public gets transformed to pubic from time to time in legal writing. So really want to watch out for the spell check 7. And my final slide for you is to give you one more tip that you can use for proofreading help. And this really helps sort of with my rules and not so much on typos. But there's this free resource called the Writer's Diet, writersdiet.com. You can go to it right now. This is just a screenshot. But you put in your writing into this little test and you run the test. And it gives you a diagnosis. Heart attack is the worst diagnosis you can get. The best diagnosis is lean, right? You want lean, but there's a bunch of diagnoses in the middle that are better than lean, but not as bad as or worse than lean, but not as bad as heart attack. And it really focuses you with this color coding system on a lot of the things we talked about today. So the be verbs, that's really passive voice. These zombie nouns in blue, these are often the nominalizations. Prepositions we talked about are the ones in green. I don't really see too much problem with add words. Those were sort of adverbs. And then we didn't talk too much about this today, but it, this, that, those sort of pronouns, one of my 3 Ps will come up in purple and allow you to fix it. So what I did for this sample was I took those 2 examples of bad writing and I put them together in that sample. And as you can see, it got a heart attack category. So I have used this a million times with students in my own writing, and I truly feel that the diagnosis that the writing gets matches what I think is good writing or bad writing. So really can be a reliable way for you to check. And if you're struggling with some of these concepts, this color coding system might help you. And so that's what I had for you today. I really hope that this was helpful to you. There are things that you can implement right away. And of anything, I want you to take away that 2 things, that writing is the most important class you're going to take in law school. And the second, and you're actually going to take 3 required semesters at Vermont Law and Graduate School. We're one of the only law schools that requires 3 required semesters. And the second is writing is a skill and you get better with practice. So make it your mission to really improve your writing between now and when you get to law school. And it will be a lifelong goal and effort. So I'm going to go ahead and stop sharing. I'm going to sit, and then I think we have about 10 minutes that I can answer any questions you have about today's class, or I can answer questions about the online hybrid JD program as well. As I mentioned earlier, I was one of the designers of the program. I teach in the program. I believe in this program. I am committed to this program. And I want to tell you, stopping sharing, other people that teach in this program. President Rod Smoller, he's our president. Look him up. He's a famous First Amendment lawyer. He teaches in our online hybrid JD program. Our Dean of Faculty teaches in our online program. Our Dean of Students teaches in our online program. This is because these are the best teachers, and I want the best teachers in this program. And I think it also shows you the high level support of the school that this program has. And I hope that's meaningful to you as you decide which program that you want to attend. And so with that, I will take your questions, and hopefully Shirley, Ellen, and Katie can help me navigate the questions.
The first one is, they're moving fast. Mr. Walker has asked, what are the hours per week commitment to the online hybrid program?
Yeah, it's no joke. So you can expect in your first year to be in class 3 to 4 nights a week. Usually the classes run from either 6 to 9 or 6:30 to 9. Not every week is class time. Sometimes there'll be asynchronous weeks, but most students are in class 3 nights a week. My civil procedure class is Monday night, 6:30 to 9. Once you get past 6:30 to 9 Eastern time, once you get past the first year, you'll have a mix of asynchronous classes. Actually, even your first summer, you'll have a mix of asynchronous classes with your synchronous classes. So that will take down the number of nights per week that you need to be in class, because those classes are self-scheduled. There's never any point where you need to be online at the same time. It's just work that you have to do. And then I think most students would tell you it's about 2 to 3 hours of preparation time for each class. So you can count on 6 to 9 hours of preparing for your 3 nights of classes. Your exams are usually just one exam at the you usually have a midterm, but that's in class. And then the exams are Saturdays and Sundays once a semester. So my students had their exam last Saturday. So it is a difficult road. I'm not going to lie to you, especially for those that are working full time and then coming to class at night. There are some asynchronous weeks, but it is not the kind of situation where you can just sort of passively sit in the background. There are also attendance requirements. You can miss class 20%. You can miss without failing. You don't want to miss 20% though, but if you do have a work commitment or a family commitment on a particular night, all classes are recorded so you can watch the video later.
Do you know the teacher to student ratio for the online hybrid?
I have 38 students in my civil procedure class this year. But I think I could have up to 50 in it and still manage to control the class. Right now, we have about 50 in here. Most professors have 2 screens. They can see everyone at once. And then I'm a very big fan of the Socratic method. So I call on people. I cold call people every single class. Actually, do I have my little... I just call them my index cards of death. Yeah. So here are my index cards. And each student in my class has an index card, and I shuffle them up and call on people each day and then take notes on what I called on them. My favorite thing, this year, this was a year-long class. So my favorite thing to do was to say, I called on you in August. Do you remember? And they don't, of course. But yeah. But different professors have different methods. Not everyone's Socratic. In fact, I'm one of the few ones I think that is Socratic, at least in the hybrid program.
I'm laughing because you also teach in the residential program too. And then when you came in, like they don't have you this semester, but you came in and you brought the cards out and they all groaned like, oh, she remembered.
Yeah. I had one student who I hadn't called on, I guess, in the first semester. So I asked a guest lecture in the second class and went in and called on him. He knew it was coming though.
Can you switch from the hybrid to full-time after the first year?
We haven't had a student do that yet, and it certainly doesn't work before the end of the first year because the sequence of classes is a little bit different. I don't know if the ABA permits us to do that. So I'm going to have to, Katie, if you could just take down that person's name, I can verify and get back.
Okay, perfect.
I've not had a student do that. What you can do though, is you can be in the online hybrid program and you can take any one of our classes residentially. So if there was a class that was offered residentially that we don't offer online, because not every class we offer residentially is also online, you could come to school. You're still in the online hybrid program, but could take that class residentially or that series of class. There's really no limit either. So there are ways. I mean, it's not an option for most people, but so there was a few Vermonters up here. So I have had that situation happen. Where a student wants to come to class. Sometimes we have weekend classes. So we have like a couple weekend classes, a couple weekends a semester. And so some people will choose to take one of them, but you're still an online hybrid student. I should also add your transcript doesn't say you're an online student or anything like that. You get a Juris Doctor just the same as our residential students do. It's really no difference.
How many residencies?
3 residencies over 3.5 years. So our program is 10 semesters, but we count the summers as semesters. So it's fall, spring, summer, fall, spring, summer. Am I doing my math right? Fall, spring, summer, fall. Yeah, okay. I'm very bad at math in public. And so you go straight through, and there are 3 residencies. There are 4 days each year. So the first residency will be in September. So you'll have been in online classes for about 2 weeks, and then you come to Burlington, Vermont, and that's where we have a 4-day residency. It's Thursday, Friday, Saturday, and you're out by like noon on Sunday. Your second residency is June the next year, so we have one in just about a month. And then your third residency is right at the end. So 3 times you come for 4 days each.
Can you talk a little bit about the states and the online program? Probably specifically, will the hybrid classes satisfy the credit requirements to sit for various states?
Yeah, so yes, but so almost every state allows this except New York. So New York has a 15 credit limit on the number of online classes you can take. That said, you can waive New York for that requirement to get out of that requirement, but it's nothing that we can't do that for you. We can help you do that, but you can petition to waive out of that 15 credit requirement. There are fully online hybrid JD programs in New York, like Syracuse and Albany, which I'm sure you've looked at if you're considering these types of programs. And so they have that problem much more than we do, because we have some students from New York, but most of I have students right now from 33 different states in my online hybrid JD class. So if it's in New York, you are going to have to do that waiver. I am not aware of any waiver for any online program being denied. But it is not something I can guarantee you. I can point you in the direction of more information about that. And I'm happy to talk with you one-on-one, or actually I would be more likely to send you to our academic success program because they know all the details about that. New York's the only state that has that problem. We're fully ABA accredited. So any other state, you can just take the bar. New York is a UBE state. I don't want to get into this too much because it's complicated, but New York is a UBE state. So you could take another UBE jurisdiction. But New York itself is going to not allow more than 15 credits, and you need 87 credits to get a JD from us.
Lamar asked, and I'm going to kind of combine both his questions. He would like to pursue a business concentration, which I think would be more general practice, and he wants to know business concentration and then the small business law clinic. So a little bit of concentrations, a little bit or tracks, and a little bit of experiential learning for online hybrids.
Yeah. So one of the unique things about our program is there are certain classes you have to take for the bar and that every lawyer needs to know. Those are your typical first-year classes, although in your case, it'll be spread over a full calendar year. After that, you can specialize into various different tracks. So we have an environmental track, as you probably know. It's sort of one thing that we're really known for. And then within that environmental track, you can specialize in energy law, food and agriculture law, animal protection. What am I missing? What am I missing from the environmental track? And just your regular environmental track. Energy, right. Okay. And then we also have a restorative justice track, which focuses on sort of criminal law or restorative justice, which is if you don't know what it is, it's a different theory of addressing harm. It has many applications outside of criminal law too. We also have a general practice track, so it seems like that might be more what Lamar's interested in. And that has just your general business type classes, business associations, negotiation types, classes like that, that sort of any business lawyer would need to know. We are in the process of developing, although I can't promise this will be ready for you. Well, I know it's not going to be ready for next year, although you'll be first years next year. We are in the process of developing a veterans law track. So we have many military families in our programs. We have veterans, and we have many families of active duty military. And so we thought that a veterans track, which focuses on the law veterans lawyers often need to use, which involves a lot of family law, bankruptcy, wills and estates, stuff like that. So we're really excited about the possibility of developing that track. We've already started, but I can't promise that it will be ready for you. Yeah, and then in terms of experiential, so all law students have to, according to the ABA, have to complete at least 6 credits of experiential work, which is sort of hands-on work. Most law schools do that through simulation type classes where you would do like a trial advocacy class or something like that. We allow you to do that through simulation classes, or you can do that through an externship. So for some people, many of you who work full-time, an externship's not going to make sense for you or be possible because you have a job during the day. But maybe if some of you are paralegals or something like that, you could do an externship in the office that you're a paralegal. You wouldn't be able to do paralegal work. There are certain requirements that you would have to meet. We have a whole department that specializes this and would talk and make sure that you're meeting the requirements and that you're getting legal experience. But it's hands-on live client work that you could do. And you could do an externship in a small business or a corporate type environment.
Thank you. Raphael asked about immigration, which is available.
We do not currently have an immigration class in the online program, but you could do an externship in an immigration law firm and get that hands-on experience that way. Or you could do an independent research project. So that's another way for our online hybrid JD students to earn credit. So I would set you up with our immigration professor, and you would do a one-on-one individual project, which you would earn credit for in that area of law. So that's another option for some of the classes that you might be interested in that we don't offer. It is a reality of this program, though, and I'll be upfront, and I think this is true of all the programs, is not every single class that we offer online is offered, or not every single class that we offer residentially is offered online, and not every single class that we offer online is offered residentially. So there are a few examples of that as well. So there is some give and take that you give in order for the flexibility of the nighttime program and without needing to move here. So it's not the exact same situation, but I feel confident that we give our students every opportunity online that we do residentially. And I think you know that I mean that because I teach in this program.
Right, exactly. We're very flexible and and what's nice is that there's 2 cohorts above this next one. And if some of you are looking for 2025, we're going to have a lot of different opportunities for students. So we usually are very flexible. Someone asked if they could do an externship at a state attorney's office, which I think, there's a lot of different opportunities. I'm going to just talk briefly about the online hybrid as far as like how many students are accepted. The program is capped at 100. Our current cohort, our cohort last year came in at 78. So we're actually pacing. It looks like we're pacing to meet our cap. So it sometimes is a little more competitive than our residential program because I can take up to 150 to 180 residentially. So just kind of keep that in mind. We do scholarship for both programs, and it's based on your LSAT GPA. In fact, we are one of the most affordable law schools in the country. I do want to give a plug for Access Lex. Access Lex is a nonprofit that helps you deal with law school debt because it is an expensive endeavor wherever you go. And I want to talk about, someone asked here, Kelly, GPA LSAT range than the residential. They pace, they're pretty close in GPA LSAT range. I will tell you this, online hybrids, the average age is about 35 versus 26 on campus. So a big difference in their scores tend to be a little bit lower. And I really look at your work experience. It's quite important to the program. Because I'll have a student who's in their mid-50s but has this incredible career and might have a lower LSAT. So there's a lot more that goes into looking at who's the right person for the online hybrid program. It's a neat group. They are, some of them I'm amazed by. I mean, Beth, tell them a little bit about, I mean, they're rock stars.
Yeah, I have a dean of a college. I have a college professor in my class. I have a lot of paralegals. I have some physician assistants. I have, like I said, a lot of veterans and veterans families that are in various work now. And I have a mom who raised 4 sons, and her last son graduated from college, and they decided mom was going to law school now. I have a lot of full-time parents in my class, so it's really a mix. The age range from our entering class last year was like 25 to 80. So it's a real mix of people I think maybe he was a little bit above. He was going to be 80 when he graduated. I think he was in his mid-70s or late 70s. He was the former dean of a college. So it's a really great eclectic group. And I did see something about mental health. Yeah, we do. We subscribe to a telehealth with TELUS, which is a fully online mental health support. Mental health support's available to all of our online students. You can see a counselor through that at no charge. That's part of your tuition. You get access to that. I want to just say one thing. I know we're running out of time, but I want to just talk a little bit about the community that's built in the online cohort. A lot of students feel like that's a risk. I think the fact that we have synchronous classes in the first year and that residency so early on, just a couple of weeks in, really does help to build community. I certainly feel like I know my online students as well, if not better than my residential students. The classes are smaller for one, right? I have 80 students when I'm on campus. And there's just a shared intimacy when we meet in each other's homes. You know, my dog, I get to know your kids, your spouses, and the fact that it's at night, I don't know, but there's something about that. The fact that the students are older for the most part, maybe too. And then these residencies where we spend 4 days together. I mean, your faculty will be with you for that 4 days. It has a little bit of a summer camp feel at times. We go dog walking in the morning. We share every meal together. We go to happy hours together. The residency in June, we have an axe throwing event. So we have a boat crew. So we do a lot of things, and it does enable us to nurture community. My online students have study groups, just like my residential students do. They meet and study together. Some of them have standing appointments every Saturday. They certainly have developed friendships and support within the online community, just as they do in the residential community. They participate in student groups on campus. They're members of the Student Bar Association. They're student leaders. They attend events on campus. Almost every single event that we have, unless there's confidential information in it that we don't want to live stream, is live streamed. Commencement will be live streamed next Saturday if you want to watch. They participate in commencement if they want to. So it's really, we try to make as many opportunities as we can that are available to our residential students available to our online. And these are deep, genuine, real relationships that students are building with their faculty as well as with each other. In fact, last winter I went to Jackson Hole skiing for spring break, and one of my students was going to be there too. So I skied with her and her partner, although I accidentally thought her partner was a little bit of a better skier than she was, and almost accidentally caused injury. But fortunately, everything was fine in the end. She made it down just fine. But whenever I travel a lot. I'm the dean of the law school. I travel a lot. So whenever I'm traveling, I'm always asking the students who's around, who wants to come to this alumni event, who wants to get together for a drink or a coffee. So you will find that you know me better than you probably want to at the end of our program.
That's so true. Well, Dean McCormick, Shirley, Ellen, thank you for participating tonight. And thank you all. Thank you so much for joining us. We were so excited that we had such a big attendance. And quick. Writing is seriously the most important thing you can do or practice for law school. Is there any online writing programs that you have? I know Read Good Writing, but is there anything that you recommend? Let's say a quick online program, anything like that?
I am not familiar with any online legal writing instruction. There are a lot of books about legal writing, and I really admire Brian Garner. I like the way he writes, and I like what he has to say about writing. Most of the tips I've developed over the years have come from him. He also has a lot of articles that are free. He has a website, and there you can find a lot of articles about writing from him that are free. He has this series where he sort of analyzes the writing of all the Supreme Court justices. So he'll have an article that says how to write like Justice Scalia or how to write like Justice Roberts. And he kind of talks about the cases too. And so those are really interesting. But I'm sure there are online programs out there. I just don't have those at my fingertips. You need to come to our program to learn.
Yeah, exactly.
Yeah. Yeah.
And then for our students, we do include bar prep in our program, and our admitted students, you're going to get more information. We do a foundations course over the summer through our academic success program. It's online, it's asynchronous, but that'll give you a little heads up before you get started in August. All right. I'm sorry, I could chat forever. With that, thank you very much. Take good care.
It was my pleasure to meet you. I hope to see some of you in August or September. And again, if you ever need to talk with me about something, admissions knows how to reach me, and I wish you the best of luck in your law school journeys.
Thank you. Thank you, everybody.
One last thing, a bunch of you asked if you could get a copy of the PowerPoint.
Yes, of course.
But I can definitely send you all a recording of tonight's event if you like.
Yeah, I will send the PowerPoint to Shirley, and she can include those that resource in your materials.
Great. So you'll get both then.
Thank you.